Welcome to Wars Jamaica. So the sexual harassment bill will be tabled in the House of Parliament pretty soon. Currently, it's in the preliminary stage, and it's titled "An Act to Make Provision for the Prevention of Sexual Harassment and for Connected Matters." In the United States, sexual harassment is a very big thing. So I'm going to play for you a skit of the United States law on sexual harassment.
The law defines sexual harassment as unwelcome verbal, visual, or physical conduct of a sexual nature that is severe or pervasive and affects working conditions or creates a hostile work environment. Conduct of a sexual nature is broken into three parts: verbal, visual, and physical. Verbal includes comments about clothing, a person's body, sexual or gender-based jokes or remarks, requesting sexual favors or repeatedly asking a person out, sexual innuendos, threats, spreading rumors about a person's personal or sexual life, or foul and obscene language. Visual includes posters, drawings, pictures, screensavers, cartoons, emails, or text of a sexual nature. Physical includes assault, impeding or blocking movement, inappropriate touching such as kissing, hugging, patting, stroking, or rubbing, sexual gesturing, or even leering or staring. There are two categories of sexual harassment. The first is quid pro quo, which literally means this for that. It occurs when a boss uses job rewards such as raises or promotions or punishment such as demotions or firing to force employees into a sexual relationship or sexual act. The second is hostile environment, which is defined as conduct that unreasonably interferes with work performance or creates an intimidating, hostile, or offensive work environment. For example, it may be sexual harassment if repeated sexual comments make someone so uncomfortable that their work performance suffers, or they decline professional opportunities because it will put them in contact with the harasser. In both types of harassment, employees must prove that the conduct was offensive to someone, not necessarily the intended victim of the harassment. Here is an example. Say a male employee tells a dirty joke to a female coworker. She thinks it's funny, but a second woman passing by finds it offensive. That joke could contribute to a hostile environment claim simply because someone finds it offensive. There are two conditions that determine liability for employers in cases of hostile environment sexual harassment. The employer knew or should have known about the harassment, and the employer failed to take appropriate corrective action. Having a training program as well as a clear procedure for reporting harassment claims can shield employers from expensive lawsuits.
So, viewers and subscribers, you just saw firsthand how the United States takes sexual harassment in different steps and different forms. Now, I'm about to give you the Jamaican aspect of sexual harassment because, as I said before, Jamaica is now attempting to adapt of this form of law into society. So I'm going to name the different offenses inside of the bill that is to be tabled into law. The Jamaican government defines sexual harassment as the making of any sexual advance towards a person by another person, which is reasonably regarded as unwelcomed, offensive, or humiliating by the person towards whom the sexual advance is made, and references to the term sexual harass shall be construed accordingly. So, what the government means right there when the government says shall be construed accordingly, when the person makes the report and that report goes to court, there's no way around it. Them interpreting the actions in that one way by within the law. There's no other way around it, no other excuse or justification. From you touch the lady or something of the sort or something relating to the offenses that I'm about to announce, you're in big trouble. Now, viewers and subscribers, listen to me keenly. These offenses I'm about to announce can and will get you caught up with the law. Number 1, physical contact of a sexual nature. Number 2, a demand or request for sex or for favors of a sexual nature. Number 3, the making of sexual colored remarks or sexual advances, sexual suggestions, or sexual innuendos. Number 4, the showing of pornography or the display of images or objects of a sexual nature. Number 5, any other physical, gestural, verbal, non-verbal, or visual conduct of a sexual nature can definitely offer you a full-blown lawsuit or possible jail sentence. So my viewers and subscribers, now I'm going to tell you who the harassment law protects. Number 1, an employee, whether in private or public sector. Number 2, a domestic worker. Number 3, a person engaged under a contract for services or a subcontractor of that person. Number 4, an employee of a person or subcontractor referred to by number 3. Number 5, a person whose service is procured or arranged by a company which is in the business of supplying workers for other businesses and who has been assigned to work in the business or undertaking. Number 6, an apprentice, a trainee, or an intern. Number 7, a student gaining work experience. Number 8, a volunteer. And number 9, a person of a class prescribed by the minister for the purposes of this definition after consultation with the minister with responsibility for labor. So my viewers and subscribers, as you can see, the Jamaican government did a copy and paste, because most of what I read just a while ago from the Jamaican Harassment bill that will be tabled in 2020 or 2021, it's very similar to the American harassment law. So the second phase of the bill, part 2 of the bill, which is prevention of sexual harassment, this part is definitely for the employers. So my viewers and subscribers, if you are working in an establishment that you experience sexual harassment and you report it to the manager or the HR and they do nothing about it, the harasser is still there, he or she is still stalking you and to you and making you uncomfortable, you have liable grounds to place that institution or organization on a lawsuit, and you're gonna win, and you're gonna win a lot of money. So make sure you report those cases readily, because in the States, the moment you report someone for harassment inside a working environment, wow, like a jet plane, HR find them quick and get them out. Because as the skit said earlier, organizations try to get those people out because they don't want any lawsuits. That's like easy money right there, and them no one giving no money, so they want you work for your money. But if it end up slide under the radar and you report it and nothing come out of it, that is big justification for you to get your lawyer and bring them to court. As always, my viewers and subscribers, thanks for watching again. Please press like on the video and subscribe as well for new videos coming out. Thanks for watching. Bless up.